I got to pay $300. I don't have $300. What about jail time? Because I don't have $300.
Okay, I can help you with jail time. You want jail time? That's what you want, jail time.
Well, I don't know what
This clip starts with a shocking exchange. A man asks if he can get jail time because he can't afford a $300 fine. The judge, with a mix of surprise and a touch of frustration, quickly accepts his request. This dramatic opening immediately grabs our attention and makes us wonder, what kind of case is this? And why would someone prefer jail over a fine? It sets a tense and fascinating tone right away.
I want.
We're in Ypsilanti, Michigan for a pretrial hearing. 65-year-old Mark Jordan has been charged with having a dog at large. 7 months earlier, Jordan was arrested after his dog was found wandering in a public area. He was released on a no-fee personal bond and pled not guilty. Today, Jordan appears before Judge Elaine Washington to discuss next steps in the case. The hearing is ready to begin, but Jordan's attorney, Davi Lebo, is still in a breakout room with another client. Until he arrives, Jordan will be represented by Assistant Public Defender Allison Moeller. The state's attorney is Paul Barnett.
All right, we're here for a pretrial today in this dog at large matter.
Yes, Your Honor. It looks like, Mr. Barnett, we're just waiting for that police report, so we would be requesting an adjournment for that reason.
No objection. I did send that over earlier this morning.
Okay. Then, Your Honor, just adjourning to go over that with Mr. Jordan.
We are introduced to Mark Jordan, a 65-year-old charged with having a dog at large. He appears before Judge Elaine Washington for a pretrial hearing. His public defender, Allison Moeller, tries to get the case adjourned because they haven't received the police report. This is a very standard and procedural request, but Mr. Jordan has other ideas. He seems eager to talk, which is a big red flag in a courtroom.
So wait a minute. We transferring this to another date, ma'am? I don't understand. I'm trying to follow along.
What she said to the prosecutor was they had not gotten the police report yet, so they need to go with the police report with you.
They called me last night, and they trying to get me to plead to a guilty charge for $100, and I don't think that's fair. The police officer, when she found my dog, she called me that night to blame my dog.
You just admitted to having a dog at large because your dog was found by someone else.
Yeah.
So you committed the crime. So you're here now, placing on record that you just did that. That's why
Yes, my dog is let loose. I have no problem with admitting that, but I have a friendly dog. My dog is not
Mr.
vicious.
Jordan.
Mr. Jordan, ignoring his lawyer's professional advice, takes over the conversation. He reveals a detail about the case that could be very important. The officer who found his dog called him to bring the dog home. This sounds like an innocent, neighborly gesture, but the judge sees it differently, pointing out that by admitting this, he's basically admitting to the crime itself. This is a key moment where the judge uses Mr. Jordan's own words against him, highlighting the importance of letting your lawyer speak for you.
It doesn't matter whether the dog is friendly or not, sir.
So that means I'm going to be charged even though I have a friendly dog and he just walked out of the yard and the police picked him on the next block and brought him home and I'm getting charged $100 for that?
Now you just admitted to the actual crime.
Okay, and so what am I going to get charged with? What is my
You're
punishment?
already charged. That's why you should be talking to your attorney and not making all these statements on tape.
My dog is not vicious.
This is not about a vicious dog. Did no one say your dog bit someone? They said that your dog is at large, which it was, because you just admitted it on the record.
My dog was at large. I have no problem admitting that.
All right, so you want to admit to the crime itself. And then
The
the fine for that
conversation
is
quickly
$300 and
spirals
something.
out of
Okay.
control. Mr. Jordan tries to argue that his dog is friendly, thinking this will get him out of the charge. The judge, with clear frustration, reminds him that the charge isn't about the dog's temperament, but about it being at large. Mr. Jordan, completely unaware of the legal trap he's walking into, repeatedly and proudly admits that his dog was, in fact, at large. He seems to think he's clarifying things, but he's just building a stronger case for the prosecution. This exchange is a perfect example of why you should never speak for yourself in court.
No, I don't want to commit to nothing, ma'am. No.
You already did. You just did.
So that means I got to pay $300? I don't have $300. What about jail time? Because I don't have $300.
Okay,
ma'am.
I can help you with jail time. You want jail time? That's what you want, jail time.
Well, I don't know what I want.
The judge tells Mr. Jordan that the fine for the crime is over $300. He immediately doubles down on his shocking opening statement, saying he doesn't have the money and asks for jail time. This is a truly bizarre moment. The judge's response is both a question and a challenge. You want jail time? That's what you want, jail time. It's an almost unbelievable request that you don't hear every day in court.
But I know I don't have $300.
Well, you're
Mr.
about
Jordan.
to get jail time because you won't stop talking.
Yes, ma'am.
Judge Washington checks back in with the assistant public defender.
Ms. Mueller, that went south very quickly. Do you want him to speak to his attorney since he just admitted to the crime on the record?
Your Honor, I think that may be best if you wouldn't mind to place him in a breakout.
The judge, seeing this train wreck, quickly intervenes. She checks with the public defender, Ms. Mueller, and acknowledges that the situation went south very quickly. Ms. Mueller wisely asks for a breakout room so she can talk to her client privately. This is a crucial, professional move that shows how a lawyer can save a client from themselves.
Room. Thank you.
All right.
Later that day, Jordan reappears before the judge, this time with public defender Davi Lebo.
Mr. Jordan, you have indicated you'd like to do some jail time and plead on this particular charge, and that's perfectly fine with me.
Your Honor, I need, how much jail time do I have to do before I agree to anything like this?
Sir, I'm not in negotiations with you. I'm going to put you in a breakout room with your attorney, and you can talk to your attorney about that and then decide what you want to do when you get back.
Well, he wasn't able to tell me that. I was asking.
Sir, please stop talking before
Yes,
you
ma'am.
get
Later that day, Mr. Jordan reappears with this actual public defender, Davy Lebow. The judge reiterates what Mr. Jordan said earlier about wanting jail time. But once again, Mr. Jordan tries to talk, asking how much jail time he would have to do. The judge, having had enough, firmly tells him to stop talking and to discuss it with his attorney in the breakout room. It's clear that even after a private discussion, Mr. Jordan still struggles to grasp the seriousness of the situation.
Jordan's case was adjourned, and a month later, he pled guilty to the lesser charge of not having a dog license and was ordered to.
In the end, Mr. Jordan's case was adjourned, and he finally took the advice of his legal counsel. A month later, he pled guilty to the lesser charge of not having a dog license and was ordered to pay a $100 fine. This is a much better outcome than a $300 fine or jail time. This story is a powerful reminder that while we all have good intentions, it's always best to leave the talking to a professional.